Good morning, everyone. Thank you for including me in your conversation and beginning discussions today on Section 37 and bonusing, and I'm really interested to hear the other speakers today as well. The purpose of my presentation today is to provide a very brief and general overview of Section 37, including the regulatory context in which municipalities, let me just see if this slide. There we go. The regulatory context in which municipalities are able to negotiate for community benefits. Just a very brief overview of existing Section 37 policies in Hamilton today. A brief summary of the policy framework, approaches, and protocols used to negotiate Section 37 benefits in other GTHA municipalities, and an overview of some of the key issues and opportunities for consideration as Hamilton thinks about potentially implementing bonusing. So this slide has a lot of information, but I'll just try to talk through it with you today. But first of all, just starting with an overview of what Section 37 is and where it's actually contained. It's Section 37 of the Planning Act allows municipalities to grant additional height or density allowance to a developer beyond what's permitted in the zoning bylaw in return for provisions of facilities, services, or matters. Benefits received in exchange for increases in height or density must have a direct planning relationship to the proposed development, and for example through the inclusion of a daycare facility if in the vicinity of that development that's deemed as something that's needed in the community. Overall, municipalities set their own bonusing policies and terms through local official plans, and at a minimum these policies typically describe one, the types of benefits that can be secured through a Section 37 agreement, including cash or in the form of something in kind, the thresholds and conditions which must be satisfied to trigger the need for an agreement, and some kind of detail with regard to the timing of the execution of agreement and the payment of cash benefits. So typically at the time of the zoning bylaw amendment, you would execute the agreement, and upon issuance of the building permit, the developer would release funds. But really beyond these limitations, there's very different approaches to how municipalities might carry out Section 37. They might opt to set out more detailed policies through a secondary plan, or create implementation guidelines to direct how Section 37 would be negotiated. Here in Hamilton, as you're probably well aware, Hamilton's official plan currently provides a policy framework for negotiating Section 37 agreements, although there are no further implementation mechanisms currently in effect. So this is how that process might unfold. There's no guidance there currently. The list of identified community benefits that are eligible for Section 37 agreement is fairly extensive and includes childcare facilities, arts and cultural facilities, public art, recreational facilities, and preservation of natural heritage features, amongst many others. Unlike other municipalities that we'll be taking just a kind of an overview of in the next several slides, Hamilton's OP does not specify a minimum threshold for triggering the need for Section 37 agreements. So the next few slides go into some examples of how various municipalities in the GTHA carry out Section 37, starting with Toronto. And if you just follow along with the graphic at the bottom of the screen, Section 37 agreements in Toronto typically comprise of three elements. One, the community benefit contributions, which may include cash contributions or a dedication of gross floor area to particular use. Back to that daycare as an example. Just for note, in Toronto, I understand that approximately 55% of benefits secured are in kind and about 45% are cash in lieu. In addition to this, there would be the public art contribution as part of the city's 1% for public art campaign, and 3, what's termed matters of legal convenience, which really may include any items that are secured as part of the rezoning, but don't specifically belong in a zoning bylaw amendment. So, for example, a dedication or a conveyance of additional lands. General policies for implementing Section 37 agreements are set out in the official plan. For example, the OP sets out a minimum threshold for developments which are required to enter into a Section 37 agreement. And the official plan does explicitly recognize additional density policies set out in secondary plans. For example, in North York Centre, there is a secondary plan that specifies the particular incentives that are provided for the provision of certain community benefits. In fact, they have a detailed benefits agreement or matrix that defines this. Additionally, the city has a set of implementation guidelines that provide direction on how Section 37 agreements are negotiated, and it's important to note that the city is currently undertaking an update to this protocol to provide more transparent, a transparent process for negotiations. In Mississauga, the city has set out broad policies for Section 37 agreements in its OP, with additional detail provided in a staff report that provides direction on process and protocol. And this staff report also describes the minimum thresholds where Section 37 may apply and also how they're negotiated. Important to note that through the negotiations process, the city will retain an independent appraiser to evaluate the uplift created as a result of the additional height and density, and has sought up to 40% of the uplift value and benefits. Burlington has a similar structure to Toronto and Mississauga in that the broad policy framework is set out in the OP with additional detail provided in an implementation protocol, although differs in that Burlington has established a value quantum like Vaughan, and I know we'll be hearing from MacKenzie on this in a moment. They also do have a separate negotiator who is actually essentially city staff from planning to negotiate on behalf of the municipality. During a review of the protocol several years ago in 2012, Burlington did implement some key changes that provided greater opportunity for public input, and specifically the city now requires a statutory public meeting to be held prior to an application going to Community Development Committee. This public meeting provides information on how possible Section 37 benefits information on possible Section 37 benefits so that stakeholders and elected officials have the time to weigh benefits against impacts in advance of receiving a recommendation report from staff and essentially rendering a decision on the application. Now, this is all interesting in the context of the fact that public consultation is not mandatory under the Planning Act, but we're seeing how it is really important as part of this process. So based on the policies and protocols that we've just kind of reviewed and just started to review really, we've identified a number of common issues and opportunities that the City of Hamilton might consider as it's thinking about the potential implementation of Section 37 here in this city. I have a couple slides on this. One is to first of all define applicable benefits in the statutory OP policies, and as I did say, the city does currently have an extensive list of potential benefits. However, it would be good to think about, are there any additional benefits that could be added or specified? For example, right now the OP talks about providing a cultural facility as one example of a benefit, but do we want to detail that more to say, for example, artist and or live-work facility? Additionally, the city should consider how to appropriately identify benefits that are subject to Section 37. Should this be based on a citywide or a downtown-wide community services and facilities study, and how could we coordinate this together with the implementation of Section 37? 2, drafting a protocols and guidelines document to provide a more transparent and consistent methodology in securing Section 37 benefits. It would be beneficial to have a clear protocol document approved by council, similar to the guidelines prepared by the City of Toronto or the City of Vaughan. and really the need to identify a process or protocol that meets Hamilton's particular needs. Additionally, is there a need to establish a minimum threshold for development subject to a Section 37 agreement? Point 3, determining the need for more precise secondary plan policies, which is really particularly important if you want to implement planning goals, following the example, for example, of North York Center secondary plan. Point 4, establishing a level playing field for valuation. This is important for the city in order to establish a measurable, transparent, and consistent process for negotiating Section 37 funds and benefits. And as we were just discussing for Mississauga, and we'll hear for how Vaughan has achieved this, this could be done through the independent appraisals of value uplift. Point 5, accounting for discrepancies between official plan and any legacy zoning. So what is the appropriate base from which you could calculate uplift? Point 6, the timing and scope of public consultation. So should the public be consulted prior to the execution of a zoning bylaw implementing a Section 37 agreement to provide input on negotiated benefits, like the City of Burlington? In Toronto, some councillors position it like, we will likely be having some Section 37s coming. What would you like to see? And this might be in addition to a community services and facilities study that would outline what the need is. But in any case, there is a need for strong integration of community needs and built form development, and a healthy discussion of the appropriate use of Section 37 funds. The role of the ward councillor in the negotiations, should this be occurring on a site-by-site basis, or should councillors be involved with the bigger picture of what the ward needs? So, for example, should councillors be more involved during the preparation of a community services and facilities study? And that forthcoming Section 37 reporting requirements, the bill is passed, but regulations are not yet implemented. So just in closing, Section 37 funds, it's important to note that they do predominantly apply to the areas of the city experiencing rapid growth, and we can see how this is a valuable tool and very important at a time when governments typically have less resources to pay for these elements. But important to note also that Section 37 cannot address the totality of public benefit needs. It is one tool to provide and fund community services and facilities, but that would be at a local community level. Thanks very much.
Thanks, Shonda. Are there any questions for the presenter, please? Councillor Farr.
Sorry, I was just, before we take questions, I was told earlier that we might be holding questions until after John MacKenzie's presentation. Is that correct?
With all due respect, we'll just ask the committee here. Would you like to ask questions after the end of each presentation, or would you like to ask it at the end of it all? Clarification questions? Sure, go ahead.
Just for clarification.
Yes.
You said the bill is cast, but implementation is not in your closing comment. Can you expand on that? I'm not sure exactly what you said, but something to that effect as you wrapped up there, Shonda?
Yes. It's just worth noting that the recently passed amendments to the Planning Act under Bill 73 requires that municipalities account annually for all cash received through Section 37, but this does not come into force until more detailed regulations are approved.
That's the province's job.
Yes, it's part of that process.
Chair, on slide 4, you have potential benefits, and you include a few examples: childcare, cultural art facilities, public art rec facilities, preservation of natural heritage features, etc., but you don't have affordable housing in the mix. That could be included in the mix.
Yes, essentially I was actually just drawing from what are existing policies in the official plan, so benefits that are currently outlined, and this is just an example of some of those elements that are captured there.
Thank you. And Councillor Vanderbeek has a question for clarification as well.
Thank you. through the chair, I'd just like to pursue that. My understanding is that the list of benefits that you have up there have to be applied within the area of, for instance, within the ward, but that affordable housing can be citywide. So can you just make a note of that and perhaps talk to that for a minute?
Sure. In the context of, if it's a benefit secured through a Section 37 agreement, the Planning Act states that the benefits would have to be, there would have to be a planning connection or a nexus to where that development is planned for and where the community benefits would be. It would have to, you would have to be able to show some connection to more that local community where that development would be. It's not to say that there wouldn't be affordable housing policies that could be applied citywide, but just not through, well, it could be through Section 37 benefits as long as you could tie it to a relationship to the development that's being proposed.
Councillor?
Thank you. That's not my understanding, so I'm going to be asking that question again to other
Okay.
presenters. So I just want to put that forward so that they know that I'm going to be addressing that, because my understanding is clearly that affordable housing, Section 37 can be applied to affordable housing anywhere in the city. So I just want to put that on the table so that that's out there. Thank you very much.
Thank you. And Councillor Partridge, clarification?
Yes, thank you. Just very quickly, Shonda, thank you for your presentation. I appreciate it. But I think the majority of the folks here are here to find out and to hear about how does affordable housing fit into the Section 37, how, you know, our OP, and how can we take advantage of that. And I'm a little bit disappointed that there's nothing in the presentation about the affordable housing connection, because I think that's clearly what, you know, certainly from my perspective, with all the development going on in Waterdown, that's something that I'm very focused on. You know, can we take a percentage of any of those developments? And maybe you could just speak to that, just to clarify. Is there anything in Section 37 or a policy that we could implement that would allow for inclusionary zoning within any of the new developments that are coming through? Because certainly I'm in a high-growth area.
Right. It's my understanding, first of all, that there are, the speakers following myself will be really focused on exactly that, the topic of affordable housing tied to inclusionary zoning, for example. So I think I'll leave room for other speakers to address that.
Okay, thank you very much.
And thank you, Shonda. I know that there's some people that need to leave, so it's kind of nice to get their questions in when they,
Great.
when they can.
Yeah.
So thank you very much. And now I would like to, may I have a motion, please, to receive Shonda's presentation? Councillor Collins, Councillor Pearson, all those in favour. Thank you, Shonda.
Thank you.